Latches, a defense. Latches is a defense that rests on the concept that one who delays unreasonably in pursuing his remedy in court, especially where his voluntary delay prejudices the other party, should not be permitted to sue. The decision is based on elements just as causes of action are. It's also supported by the maxim of law. Long sufferance equates to acquiescence or agreement. If somebody stabs you 10 years later, they win the lottery, you can't come after them 10 years later down the road saying, yeah, he stabbed me, now he's worth something, and I have a cause of action. So latches, okay, that's what we're covering. Elements. In order for defense of latches to lie, defendant must prove each of the following elements. Some genuine basis for the plaintiff's lawsuit, i.e. conduct on the part of the defendant giving rise to the complaint. Otherwise, the defense is not necessary. 2, plaintiff had knowledge of defendant's conduct giving rise to the complaint for an unreasonable time before filing suit. 3, plaintiff had a reasonable opportunity to file suit sooner. 4, plaintiff unreasonably delayed filing suit. 5, defendant lacked knowledge plaintiff would assert the right on which suit is filed. 6, injury or prejudice to the defendant if relief is granted on the complaint. Now, somewhere where latches really doesn't occur is fraud, okay? However, people say that fraud does not have a statute of limitation, and that's an egregious misnomer, and this is what I want to convey to you guys, all right? From the moment you give notice to the public of the fraud afoot, there is a clock that begins to tick. And remember, after you discover the fraud and you don't take action, long suffering equates to acceptance, okay? All right. The fundamental doctrine underlying the defense of latches is whether and to what extent the plaintiff's delay has lessened the defendant's ability to defend. For example, if a key witness has died during the interval, defendant may have a hard time proving he is not liable for the damages plaintiff seeks. In some cases, delay may actually preclude the court from arriving at a just result because the span of time has made it too difficult to determine the truth of matters asserted by the respective parties. Depending on the jurisdiction, in most states, the defense of latches will not be heard until the statute of limitation has run. Problems arising when the statute is told for one reason or another, i.e. when the clock is stopped. Consult local statutes and case law. Now, because my knowledge is extensive in trust law, okay, in the exclusive jurisdiction of equity, and I'll tell you right now, a wrong is a wrong is a wrong. If the wrong happened today, tomorrow, 10,000 years ago, equity is a time traveler. Equity in the exclusive jurisdiction of equity will allow you to go all the way back 10,000 years and correct the wrong, okay? It doesn't mean that it will come in the form of compensation, but a fact will be established, the record will be corrected, and we can move forward, okay? That's what I like about equity. On the legal side of things, not so much, okay? Okay, defense. Defense to this equitable defense include the following. Excuse. Once a defendant has succeeded in showing the elements of the defense exist, the burden then shifts to the plaintiff to show his delay in filing suit was through no fault of his own. Perhaps he was unable to sooner obtain necessary evidence. Perhaps he knew of the wrong but did not know the identity of the wrongdoer. Under such circumstances as these, the plaintiff may be excused from filing sooner, and the defense of latches fails. Infants. An infant, which term in law generally means anyone younger than the statutory minimum age required to bring suit, is excused from filing suit during the period of his incapacity. However, as soon as he is of age, the law imputes to him a duty to timely file an action against those who he claims caused him injury during his minority. For details, see local statutory authority and case law. And I hate case law. Again, I'm gonna scream this from the fucking rooftops. Nowhere in the Constitution has the judiciary ever been able or been granted the authority to create law. It's case precedent. I really hate that these lawyers muddy the water by calling this shit case law. It's an egregious misnomer. It's case precedent. Comments. Latches is an affirmative defense that must be raised by the responsive pleading, i.e. the answer, or, if permitted in the jurisdiction, reasonably soon thereafter. If it is not affirmatively pled at the beginning of the case, it is deemed to have been waived. The burden of proving each and every element of this defense is, of course, on the defendant, and in most jurisdictions, it must be proved by clear and convincing evidence, as opposed to the greater weight or predominance of evidence. Unlike statutes of limitations that apply to actions in law, latches is a defense in equity that looks behind the scenes, so to speak, to examine the prejudicial effects of the delay and applies the defense to prevent injustice. Statutes of limitations simply tick off the time and more or less mechanically bar suits at law thereafter. Latches only bars suits in equity when not to do so would cause an injustice because of plaintiff's unreasonable excused delay. Application of the doctrine depends on the facts of each individual case. The mere pages of time does not give rise to this defense. Each of the elements must be alleged and proved. Malicious prosecution. Malicious prosecution is available to award damages to those who successfully defended a previous lawsuit that was brought without sufficient legal justification, denial of due process of law, or insufficient facts, so on and so forth. You weren't federally indicted, you weren't grand jury indictment didn't exist, there was no cause for a warrant, blah, 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 blah. You've proven all these facts, right? So you were acquitted or the case was dismissed. Now you have grounds for malicious prosecution. It does not arise until the successful conclusion of the previous case, i.e. until the defendant in the previous case has prevailed and additionally can show that plaintiff in the previous case had no probable cause to sue in the first place. Elements. The essential element that must be alleged and ultimately proven are: 1. A prior proceeding against the present plaintiff was commenced, criminal or civil. 2. Defendant in the present case was the direct cause of a prior proceeding. Defendant in the present case need not have been plaintiff or prosecuting party in prior case if he was person substantially responsible for commencement or continuation of the prior case that was ultimately found to be without meritorious foundation. 3. The prior proceeding terminated favorably to the defendant there, plaintiff here. 4. There was no bona fide probable cause or legal justification for the prior case. 5. Defendant in the present case caused the prior case with actual or legal malice. 6. Plaintiff in the malicious prosecution case suffered damages for the prior cases. Defense. Absolute immunity. Government prosecutors are entitled to absolute immunity for prosecuting for malicious prosecution. I'm going to tell you right now, that's bullshit. They are not. They have a job to do, okay? Government prosecutors are supposed to go and look at the facts, collect the evidence, weigh the controversy, and decide whether or not there's substantial evidence, reasonable articulable suspicion, and reasonable articulable facts to bring a cause of action. If they don't do that, they do not qualify for fucking immunity. I think it's absolutely atrocious that the legal system would even dare to say that, because again, it presupposes that nobody's above the law, okay? None of these jackwagons get a fucking excuse or get out of jail free card, all right? They may say that the prosecutor can't be prosecuted, but the man who at times acts like a prosecutor had a duty to fucking know better, and you can absolutely tie his nuts to the fucking wall, and I would advise you to do so. However, individual private actors are not, and that includes actors who, for malicious purposes and without probable cause, instigate criminal actions against others, who then have the remedy of this cause of action in a civil court. Dismissal on technical grounds. If prior case terminated for any reason other than innocence or lack of lack of liability of the defendant therein, plaintiff in malicious prosecution cases, the cause of action will not lie, because the result does not constitute termination favorable to the defendant in the prior case, i.e., it was not determined that the defendant was without guilt, culpability, or civil liability. In order for a defendant in a prior case to have a cause of action for malicious prosecution, the prior case must have adjudicated him without fault, dismissal, or other termination on technical grounds, or even a stipulated settlement unless the stipulation states the defendant was without fault, does not give rise to this cause of action. Bona fide termination. Another point to hold in mind when considering the cause of action is whether in the prior case the plaintiff there, defendant here, was afforded a reasonable opportunity to prosecute his claim. If prior plaintiff was unable to complete discovery, for example, it may be found that his failure to prove the plaintiff here, defendant there, at fault was not the result of the justice, but circumstances beyond his control. As stated above, in order for this cause of action to lie, the prior case must be terminated in favor of the defendant there, and termination must be bona fide, i.e., in good faith, with the plaintiff there, defendant here, having been allowed his day in court. Counterclaim. Malicious prosecution may not be pled as a part of a counterclaim, since it must be first proven that the defendant in the prior case was without fault, and that requires complete bona fide termination of the prior case. Malice. Malice may be either actual, i.e., the state of mind of a prior plaintiff to harm the prior defendant, or legal, i.e., inferred from circumstances such as absolute lack of probable cause that a reasonable person would recognize, even though no evil intent can be proven. Nolli prosequi, 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 Nolleprosequi. If the government prosecutor, in good faith, enters a nolli prosequi, or declination to prosecute in the prior proceeding, the essential element of a bona fide termination in the prior defendant's favor is satisfied. When we come back, we'll be talking about negligence. We'll be talking about quantum merit, promissory notes, replevins, and rescissions. All right.